The Parliament of Canada promises to keep implementing Canada's human rights obligations. Report to the Standing Senate Committee on Human Rights. December 2001. As we have said earlier, Canada has made a significant contribution to the development of international human rights. Canada was at the table and played a key role in the drafting of the Universal Declaration of Human Rights, which was unanimously adopted by the United Nations General Assembly in 1948. Despite the fact that human rights were not always respected in Canada, or perhaps because of that, we were able to bring our experience and perspectives as a diverse and relatively young nation to the international stage. The end of the Second World War was a defining moment for the international human rights. There was, at that time, an increasing recognition suggested in the preamble to the United Nations Charter that individual human beings, and not just nations, were the proper subjects of international law and rights. International criminal tribunals were holding individual state military and civil officials responsible for crimes against humanity, often committed against their fellow citizens under the cover of national law, as well as for traditional violations of the laws of war. There was a gradual awakening to the idea that all the people of the world had or should have certain human rights as a minimum guarantee, and that nations and governments should be accountable under international law for respecting these rights. The Universal Declaration was an explicit recognition of this ideal, but it was not in itself a binding legal instrument. So the work began to create actual treaties obliging the governments to accept and implement human rights in their countries. The two international covenants adopted by the United Nations in 1966, one on civil and political rights and one on social, economic, and cultural rights, were the key results of these efforts. Other international human rights instruments covering more specific fields would soon follow. Canada often played a key role in promoting these efforts and moving them forward. Canada is, of course, a party to the 6 major international human rights instruments, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. So what I just read you is coming out of, stemming from, flowing forth from the Parliament of Canada. This is a report that was produced, that was given, and that made the Parliament of Canada aware of what is transpiring here on its territory, in its state, concerning our human rights and freedoms. Now in that first little section we saw that it says that the Parliament of Canada or the Canadian government are a party. They are definitely a party. So if you were wondering, if you've seen my other videos and you've heard about the Universal Declaration of Human Rights and Freedoms or these international covenants, and you weren't quite certain if Canada was indeed a party to these covenants, well, it's very clear based on their own reports that they are for sure a party to these international covenants. Now, as being a party to it, it clearly states that they should be respecting these covenants. That the human beings that these covenants affect here on their territory should be able to exercise their rights that are drawn out of these covenants. The government has obligations and duties towards these covenants. It's an obligation, a duty. We, in our lives, we can't just close our eyes when we have obligations or duties. If we do that, guess what? They'll pile up and they'll come back to bite us. They'll hurt us, usually, if we forego our obligations or responsibilities. However, it seems that Canada wants to forego their responsibilities concerning human rights and freedoms and not fulfill their obligations and duties. And their own parliament, Canada's own parliament, writes a report and states that fact. That although they're signatories and although they agree that Canada is doing a lousy job when it comes to human rights and fundamental freedoms here on its territory. Canada's domestic implementation of its international human rights obligations. The effect of international human rights law on Canadian law. Canada is a dualist state, meaning the international treaties to which Canada has adhered do not in of themselves alter its domestic law. So you hear that. Internationally, treaty law must be incorporated into Canadian domestic law through legislation in order to have direct legal effect. Therefore, while signing and ratifying an international covenant gives the illusion of Canada's compliance, in reality it has no legal effect in our domestic law. Canadians, including lawyers and judges, know little about international human rights law, although this is slowly changing. In this report, they make a statement, and I agree with the statement that's being made here. It states that Canadians, now notice that, Canadians, referring to the human beings who have been given this title Canadians, but the human beings, the men and women that live here in this province. Canadians, including lawyers and judges, know little about international human rights law, although this is slowly changing. So they admit it. The Parliament of Canada admits it, and they declare it, and they say that Canadians, including the lawyers and the judges who are sitting on the judicial benches, who are sitting in the positions of power, they know little about international human rights law and how to apply it and what it means to me personally, or what it means to you personally, against this commercial system. Canada's approach to legislative implementation. Although legislative incorporation is necessary to fully implement treaty rights and obligations, the vast majority of Canada's international human rights treaty obligations have not been the subject of implementing legislation. This means that Canadians cannot, through their courts, compel government respect for their international human rights. As such, this appears to be contrary to the spirit, if not the actual terms, of the international human rights instruments themselves. For instance, Article 2, Subsection 3 of the International Covenant on Civil and Political Rights requires states to ensure that any person whose rights or freedoms as herein recognized are violated shall have an effective remedy. To ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial or other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. To ensure that the competent authorities shall enforce such remedies when granted. The requirement clearly expressed in the provisions for states to ensure that their people have a mandatory right to effect and enforceable remedies, preferably through a judicial determination, for violations of the rights set out in the covenants, strongly suggests that the effective incorporation of the rights of the covenant into domestic law is intended. Any doubt on the matter should be eliminated by Article 2.2 of the covenant, which provides, "We're not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of this present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant." So one of those obligations, one of those duties that Canada has, that the Parliament of Canada has, that the politicians of Canada has, that everybody who is sitting in the position of the Senate of Canada has, is that domestic law, the laws that they created here in Canada, had to reflect or implement international law. So the laws here that are given royal assent through the Governor General, as you have learned on other videos, those laws, there was an obligation to make sure that the fundamental rights and freedoms of the human beings were incorporated or included in the domestic laws. That's an obligation. As Canada being a signatory to the international treaties, to approving of them, to helping construct them, and signing upon them, well, their obligation was, their duty was that when they created domestic law, you had to make sure that you respected the international laws. And those international laws, as you have learned hopefully from the videos that I've placed up on my YouTube channel, they were concerning the fundamental rights and freedoms of a human being. This is a declaration on the right and responsibilities of individuals, groups, and organs of society to promote and protect universally recognized human rights and fundamental freedoms. Each state shall adopt such legislative, administrative, and other steps as may be necessary to ensure that the rights and freedoms referred to in the present declaration are effectively guaranteed. Domestic law, consistent with the Charter of the United Nations and other international obligations of the state in the field of human rights and fundamental freedoms, is the juridical framework within which human rights and fundamental freedoms should be implemented and enjoyed. Article 15. The state has the responsibility to promote and facilitate the teaching of human rights and fundamental freedoms at all levels of education, and to ensure that all those responsible for training lawyers, law enforcement officers, the personnel of the armed forces, and public officials include appropriate elements of human rights teachings in their training program. So that report states that lawyers and judges and Canadians know little about human rights, but then we look into an international covenant, Article 15, and look whose responsibility that was. It is the state's responsibility, the Parliament of Canada, the Government of Canada. It is the state's responsibility to promote and felicitate the teachings of human rights and fundamental freedoms at all level of educations. At all level of education. So when we were in school, high school, college, even elementary school, it was a responsibility that they should have taught us. They should have explained to us what are the fundamental human rights and freedoms that are available to us as human beings. Why don't they do that? Because that is totally against the commercial system. Because the rights and freedoms that are extended to you or granted to you because of these charters conflict the domestic law, conflict the authority and the de facto power that they use against you, and it strips them of that power, and they don't want that, so they don't promote it. But furthermore, this article says that, and to ensure, look at that guarantee, to ensure the teachings and the knowledge of human rights and fundamental freedoms are incorporated or given to the lawyers, the judges, the police, public officers, and all the rest of those who sit in the ruling de facto powers. It was the state, Canada's responsibility to teach them all this. And then in the report they say, well, they don't know human rights and fundamental freedoms, but it was your responsibility in the first place. So if you're failing, it's the Parliament's fault, not the ones who are sitting in these positions. Because listen, these people who are now lawyers and judges and police officers and public officers, when they grew up as children and they went and got their education, they went to, if you will, provide themselves a life. They're looking for a paycheck. They're looking to support their family, most of them. They're looking, you understand, to make their way in this world. It was a job for them, most of them. It was a way for them to survive. We can't blame the human beings who are holding these offices. That's not the problem. It's the offices or the roles themselves that are being played, the knowledge that was not dumped into these roles. For example, if you go to be a lawyer, well then there should have been a part of that knowledge as a lawyer that taught you and showed you about human rights and fundamental freedoms that are in operation in Canada, apart from and in domestic law. But as you see, Canada itself reports that they don't do it. They don't do it. So then when we deal with the individual human beings who work in these roles or offices and they have no idea what you're talking about because they've never been taught themselves, they're not to blame. You can't get angry at them. The one to get angry at is the state party itself, Canada, and start to make demands to say, well, what's going on? You had an obligation. This is the Interpretation Act of Quebec. This Interpretation Act is just like the Interpretation Act of Canada, but it only applies here in Quebec. Now when you look in Article 51, it says, whenever it is provided that a thing shall be done, or must be done, the obligation is imperative. It means that you have to. There's no excuse. You must. This is what you would consider domestic law. This is applicable here in Quebec. It's titled the Quebec Civil Code. Article 2803. A person wishing to assert a right shall prove the facts on which his claim is based. A person who alleges the nullity, modification, or extinction of a right shall prove the facts on which he bases his allegation. Quebec Civil Code, Article 2806. No proof is required of a matter of which judicial notice shall Now notice that, shall be taken. Continue down, Article 2807. Judicial notice shall be taken of the law in force in Quebec. However, statutory instruments in force in Quebec but not published in the Gazette Officielle de Quebec or in any other manner prescribed by law, and international treaties. You see that? Let me take away the green. International treaties and agreements applicable to Quebec but not contained in a text of law and customary international law shall be pleaded. So you look into the Civil Code of Quebec. That is domestic law. That is law that was created and given force of law, royal assent, by the Governor General's office. Here in Quebec, it was a judge who gave it because of the situation that's going on in Quebec. But nevertheless, that's domestic law. Now, within that domestic law, as you've seen the 2 articles of law that I just read to you, or the 3 articles of law that I just read to you, it says that judicial notice shall be taken of law that is in force in Quebec. So they use the word shall, and they're saying that it must be taken. Now, international treaties such as the International Covenant on Social, Economic, and Cultural Rights and the International Covenant on Civil and Political Rights, international treaties shall be pleaded. So you must bring them forth. You must speak about them. Now, they use that word shall twice when they're referring to the human rights and freedoms. Now, shall produces an obligation. Now, there's an obligation in both ways here. It says that international treaties shall be pleaded. So it's up to you to plead them. You have to know them, know where to draw your rights from, and then plead with them to the courts, whatever court you are involved in. And then it says judicial notice, there's a responsibility on them, shall be taken of law in force in Quebec. So once you plead these laws to them, to the judge who's sitting in there, even if he doesn't know them, there's supposed to be an obligation, there's supposed to be an accountability for them to take judicial notice of these laws, because these laws are indeed in force in Quebec. They are under the obligation of these international instruments. So you have to obligate them by pleading these international treaties, and they have the obligation of taking judicial notice. So here in Quebec, we actually have the expression. We have the expression of our fundamental rights and freedoms available for us. When I studied the laws, and I've made videos about this here on YouTube concerning the Canadian Constitution, the articles of law in there which apply to our freedoms, and subsequent enactments that they've made across Canada which apply to our rights and freedoms. So there has been some attempt at getting international responsibility or international obligations into domestic law, but it's been not a great situation here for sure. Because as you've seen in that report, and I can tell you from personal experience, and I could bring a number of people to sit here and give you a personal witness, how they've come up against lawyers and judges and police officers who have basically no understanding of what human rights and fundamental freedoms are, and what that attributes to you on an individual level as a human being. And they violate your fundamental rights and your fundamental freedoms without probably doing it on purpose, but nevertheless they do it. That's the condition that we are sitting here in Canada. So it's up to us as an individual, as a society, as human beings, to begin to learn how to use these laws on our behalf, and to go into there and to begin to plead our fundamental rights and freedoms, and make them take judicial notice. Because right now, they are very much aware that it is a sad situation in Canada. Although we parade around with flags and with words and songs and violins about how great we are concerning our human rights and fundamental freedoms, from the basic fundamental right and freedom that we have as a human being is not even respected here in Canada. Not even respected. So it's really, really sad.